Jay, walk us through yesterday. What did it mean to you? What's it mean to the sports world of the NCAA?
Well, it was a profound error in judgment on the part of the NCAA to petition the Supreme Court to hear that case, because the lower court ruling in the Ninth Circuit was actually pretty good for the NCAA, and it preserved amateurism and what the NCAA considers its right to limit players' compensation from schools and from third parties. So that was the first thing that hit me, was how stupid and incompetent it was for the NCAA to take that step. But really, Dan, what this was about was, the Supreme Court took this case because there was a circuit split among federal courts with regard to how these cases were being decided. And so what the NCAA really lost was its deference from the courts and the presumption that their rules were pro-competitive. And so now every case they're gonna have to go through this rule, what's called a rule of reason test, which means they're gonna have to show and prove that there are pro-competitive aspects to what they're doing and not anti-competitive. And like what you just read from Justice Kavanaugh's concurring opinion, it's going to be really hard for them to do that. I don't think they're going to be able to. And so that was a huge mistake they made. I think what this does now is it opens the door for further litigation that's not just going to be on, laptop. It's not going to be about laptops and tutors and internships. It's going to be about name, image, and likeness, and it's going to be about contracting with the university for pay. And I don't think there's any way that the NCAA is going to prevail on these cases going forward. And the only hope they have is going on both knees to Congress and saying, please give us an antitrust exemption, which you've given to no other multi-billion-dollar business in the country. Please give it to us, because we've proven that we can do this right. And I don't think they're going to get that either.